live and online, although our screen
is not live and online. So look, perhaps I can just, for a start, acknowledge the traditional owners of the lands in which we meet throughout Australia, and to pay our respects to elders past and present. It's NAIDOC week this week, a very important week for the Aboriginal and Torres Strait Island people, many of whom we act for in our in both our pro bono practice and in our advisory practice. What I might do is I might just get Karen to step out while I start doing some things just to try and fix our screen, because I think you can see us, but we can't see you. Could you just check?
Yeah, absolutely. Yeah, give
what's
me a
going on? And I'll kick off with some of the things that are happening for us this week as well. No, we're still there. It's all right. A couple of very important changes that have happened, most particularly in Victoria on the long service leave. Karen would probably like to have a comment about this, but the issue in long service leave has changed very dramatically from 1 July in Victoria. And that dramatic change has this effect, that if you do not pay it, and that's commonly the case with things like contracts and casuals where people misunderstand their obligations around it, there is a fine, a daily fine of over $10,000 in individual fines. And these are not maximum penalties, they are fixed penalties, okay? So do we know what's happening, Karen?
Well, Sophie does, and yeah, she'll come through and say
so Sophie's going to come and fix this for us today. We occasionally have glitches, and today we're having a small glitch. There we are. Hallelujah. Isn't that just terrific?
Our hair looks great.
Yeah, our hair, but our shoes. No, we've got white shoes. So I just want to say that today. Without doing it, we actually turn up the same. Wow. Talking about the long service leave,
yes,
the real risks that sit around casuals and contractors and not understanding the obligations they have to pay. The very significant fines, which are fixed fines, they're not maximum fines. So in other words, they just happen. The only space you've got is under the prosecutorial guidelines is they may do a deal with you to fix it. But once they prosecute you, go on and it's a criminal offence. So big change, Karen.
That's significant. And in fact, as a HR practitioner, and anyone who's looking after payroll, that's quite frightening to me. And probably the thing I'd be thinking is, well, is long service accruals, or do we have like clear visibility in terms of how we're managing that, and are we fully compliant and doing that correctly? I'm thinking also, Andrew, with organisations where there's a lot of contractors, casuals, long-term, casuals been working for years.
Yeah.
But what about also businesses who have also merged, and transmission of businesses?
I know, and look, the warranties, you need to be very careful of warranties you have under the contract. But look, let's move on because we've got a lot. Yeah. Scaffolding code in Queensland has come out, which lifts up to higher levels of responsibility what was previously under the Australian standard. That looks at minimum heights of steps. It looks at engineering design for certain types of more complex scaffold. It has a clean-up responsibility that sits around it. It's a very substantive code, and what I want to be very clear about is, given there are specialist scaffold suppliers, but a whole lot of builders do their own scaffold work, this is what is reasonably practicability across Australia, because the Australian standard is obviously deficient, and that's why this code has come in. It's not in any other state or territory, but it will be adopted in other states or territories. And when you breach in another state or territory, they will look to the code as to what is reasonably practical. So please, if you're doing scaffold, read it and learn it. Okay. Last sort of general thing is defamation law has changed in all code-based states. So other than New South Wales and one or two others, there have been very significant changes that happened on 1 July. Defamation law is being used all the time in employment law now with senior executive employees. We saw it in the case of Wong and NAB that we talked about last week. It's been a real problem in employment law because obviously when you announce a change that affects a person and it adversely affects their employment now or in the future, and what you said was not true, or there are reasonable imputations, which are the meanings from the words you do, which are not true, and even worse, if they're malice, if they're said out of anger. By the way, in defamation, when we say malice, that is the damages part of defamation. So if you do something with an intent to hurt someone, that is when the damages are massive. And although the damages are capped under the new legislation, there are still cases that talk about aggravated damages that get around that cap. So defamation law up until 1 July in Victoria, Queensland, ACT, those sort of pretty scary because we're seeing more of it done by plaintiffs' lawyers. Not as scary now, and that's because they've changed what is the definition or jurisdictional definition of what can commence a claim. Prior to that, you didn't have to prove serious harm.
Mm.
Now you have to show there will be serious harm. There has been serious harm done. The problem in employment law is that's not that hard to prove.
Mm.
All you've got to show is I can't get a job.
Yeah.
The other nasty part, of course, is you're allowed to jurisdiction pick a bit in defamation if it's through social media, because it's the place in which it's read creates the cause of action. So look, we'll talk more at other times when other cases come up about it, but I just want you to know, I want you to stop and think when you're about to say something about an employee or a past employee, about their conduct or about action you've taken about them, and think these two things. One, is it true? And secondly, why am I saying it? What is the net benefit of me saying this? Because a lot of stuff that people say about present and past employers is emotional garbage.
Yep.
It's noise, and it breaches the values of who you are, but people say it. But the moment you publish it, if I say it to Karen, I've published it. For defamation, you've got to have an untruth. You've got to be able to identify the person you were talking about, and you've got to publish it. They're the three elements, okay? Yeah. So the moment I say, but imagine if I send it round as a memo. Oh. Imagine I sit in staff meetings and I say, as you're aware, some people last night got very drunk at a Christmas party, and everyone knows it was Fred, okay? That sort of behaviour won't be told. It's disgraceful behaviour. No, I might be angry, but it is the dumbest thing I've ever done. Yeah. Okay? It's unhelpful and it's unfair to Fred. Okay?
I'm sure it's happened a lot at places we've all worked for, Andrew. So this is a timely reminder.
I think it's just a time to bring us back to our values and the way we behave. We don't say bad things about people. We may tell truths about things that occur, like the termination of someone, and there may be lessons that need to be drawn. Yeah. But gee, they'd want to be truthful and for a good purpose. Let's get on to Barinski and Sydney Trains, because we've talked a lot about out-of-work conduct of a criminal nature and what is the law around it. And this is the most recent case, and it is a fascinating case for a couple of reasons. Barinski blew 4 times over the legal limit when he was driving. He was a train driver. So there's your connection. Would you get in a train with somebody who drives cars when he's 4 times over the limit? The first question is, who would know? Just want to put that out there. He did it, and he advised his employer immediately. He read the code of conduct and felt he had to advise them. They would never have known about it otherwise. He'd had 3 deaths in the family. His life was in chaos. He explained all that and was incredibly apologetic for what it did. Sydney Trains looked at their code of conduct, a fairly ambiguous code, and said, look, that was behaviour that goes to the nature of what you do. You're a train driver. You drink drive. There's the connection, and you're damaging the reputation of the organisation. And the commissioner did 2 things. One, looked at Rose and Telstra. Remember the 3 tests in Rose and Telstra, and said one of them damages the reputation of the organisation. Now, remember, we've talked about a case about an Aboriginal ACCHO or a health authority where a guy who was meant to be training and educating young men in violence and alcohol then went and attacked his wife and was locked up overnight and was publicised and everyone knew about it. And the court said, well, yeah, it's not so much a reputational issue. You can just never come back to work because the very thing you do, you've gone and breached. And that was the argument that was relied upon in Barinski. And what Commissioner said is, well, that's not the same here. Nobody would know this person was the driver. It's not the very sort of misbehaviour. And most importantly, there is no evidence of damage to reputation or risk to the organisation at all. And if you were going to run this, you'd have to prove the damage to that reputation. Yep. So that's the case at its highest level on Rose and Telstra, and why it's a fascinating case. Because I think it's the first case we've had which really embellishes what the law is that sits around it. The second case is the thing you and I talk about every day, codes of conduct.
Yeah.
Here was an ambiguous code of conduct, and here was a set of employers who thought, we've got a valid reason, and they're unfair dismissal. We've got a valid reason, we'll terminate. Where was the understanding of harshness in this? Okay, complete failure to exercise the discretion should have been exercised for a person going through traumatic therapy. But the code of conduct lacked the clarity to actually connect the dots. So please, when you've got a code of conduct, don't just say to the HR person, can you create a code of conduct? It is one of the most important documents in your whole business because it says who you are.
Yes, and certainly also in managing this, don't refer to the code of conduct. The code of conduct is very important, but also don't conveniently refer to that as a mechanism to be able to manage that without considering other factors as well. I think that's the case.
Yeah,
here also.
and it is. Look, we talk about it every day. Valid reason, then harsh, unjust, unreasonable. Well, valid's just the first threshold. Victorian worker cover and recruitment select is the next case. I'm doing this because we've got businesses who use labour hire, and we've got a labour hire business. Labour hire employee went to a business. They relocated him to a part of the business he wasn't hired under the host relationship to do. He did a job which was inherently dangerous. He wasn't supervised. He died. They're the facts. The host is going to be incredibly liable and will pay huge penalties in respect of it. But at the moment, the labour hire provider has pleaded guilty because they didn't have a system that identified the moving of their staff, nor, because of their duty can never be taken away, did they have a method of safety or a system of safety around ensuring that their employees were safe when they're placed with someone. Now, a really important issue for everyone is this actually should be in the labour hire contract. The responsibility should be clear. We're always drafting them for both sides and amending them. But can you really be clear about this? Both the host and the labour hire provider have duties of responsibility under safety legislation that cannot be contracted out. So please don't. And the last case, and I'm sorry we're going at speed because we were caught up early on, with our screen, not your screen, with Haria and Comcare, which was a workers' comp case where a woman developed an acute psychiatric episode while she was at work. She said it was a result of something that occurred at work. It was not true. She had an underlying depressive illness, which she hadn't disclosed. It was a feature of underlying depressive illness that she had. It was not caused by work, but her dishonesty and the circumstances led to a denial of liability by the insurer. Why is that important? Well, in both Victoria and Queensland, the legislation permits you to get a statutory declaration from somebody as to their pre-existing injuries, which must be answered. And if they answer that dishonestly, then they will be denied insurance. In every other state and territory, we've got someone sneezing next door who's not meant to be next door. So sorry about the sneezing noises. They're killing me today. What's happening today? I don't know what someone's got.
We're talking about the stat decks. And
so in every other state and territory, you are allowed to be satisfied before someone starts work. They're fit for the inherent requirements of the job, and that does allow you to ask questions around the person's health status.
Yeah.
So that's what this case
But that needs to be done prior to the offer of employment, not after. So the timing part of it is critical.
And it must be in their contract of employment. Okay. So there's just a really short, pretty case with someone coughing in the background who's not meant to be in that room. All right, I need to have a break. So Karen, I'm going to hand over to you. Go.
Yeah, well, this is quite timely because I'm actually today. I don't have a slide for you guys, but I do want to write. We've been talking about well-being for some time now. It comes in, it arises as themes throughout our briefings, and we talk about employee well-being. We talk about in terms of organisations needing to invest or have a strategy in this area. Yet one area we have not talked about, and what there is not great coverage on, Andrew, is CEO well-being. Perhaps we had a moment of it just there with you. So. Look, the research that has been conducted so far is that I've got here that half of CEOs struggle from a mental health condition, and that CEOs or leaders of organisations are twice as likely to experience depression. So interestingly, what we're going to do as part of a bit of a survey and our own research more locally is that my team have developed a series of questions, and we're going to be reaching out to our network of CEOs and organisational leaders to get your insight around how COVID has impacted in terms of your ability to lead or your leadership style, what you're doing with wellbeing, how that's changed, what investment has your organisation made, and we're going to collate that information together. We're going to share it with you next week. So with the audience here in terms of our findings. So, it's not a global research piece, but I think locally it'll be really interesting. I think that there's an academic called Robert Frost, who we were just talking about earlier in the green room while we're having breakfast, who did a fascinating piece. Robert Frost was an academic who developed cancer and sat in the hospital and watched the impact of patient behaviour on nurses and started to see that there's this transference of pain across to people. And then he studied the impact of what he called toxic employees, probably a phrase we wouldn't use much these days,
on the people who try to manage them.
Mm.
And I think, as Karen says, this is a really critical part of what we do, because we don't, from supervisors up, we don't build resilience.
Mm.
We assume resilience. But as a CEO or executive leader, we just assume they're psychologically fine. And in fact, if you look at what we've been through in the last few weeks with the massive change that's been going on in our organisation, it creates, and you know, like, it's a wonderful experience we're having at the moment as we grow as a business and develop a Sydney office.
Yeah.
But I can tell you, it has an impact, a very significant impact.
And it's a very, look, we hear the term that leadership is a very lonely space, and there's a lot going on. And what does your support network actually look like there? And how often or when do we actually ask that question, rather than assuming that, look, do you need some support? But what is it that you need versus what another CEO might need based on?
And how do you ask upwards? Yeah. I mean, one of the interesting things is most people assume that I'm a robust and strong soul, and that's probably true. But not many people find it easy to say to me, are you okay? Yeah. They don't, and there's a reason they don't do it, because I've got to look like burning fires in my eyes. They ask, are you okay? I'll give them a clip around the ear. But anyway, that's part of what we want to get to is, well, what is the impact? And then actually, what are the solutions? So we both thought we could do this as a group.
Yeah, we did. And it'll be great because we'll be able to get the insight from leaders from across various different industries and sectors. So I think it'll be interesting for all of us. I'm looking forward to sharing that with you.
Yeah, and we've also got someone now drilling in the building, which...
This is just our day, isn't it?
This has got to be... This is such a shit day. Okay, health information, not from you, from health information. I just want to deal very briefly with what are you allowed to do with health information. We've talked about Victoria and Queensland. For those who don't know, it's Section 41 in Victoria under the Workers' Comp legislation. It's Section 571B in Queensland, which allows you to specifically ask questions. Again, ask Kim about that. She'll give you the document. There's a declaration that we use. Privacy legislation allows you to collect information around employment. Okay, so it is personal, it is sensitive information, but there is an exemption for employment records. So I want you to think about that. That is for employment, for no other purpose. So as you collect information, it's not only the collection, it's the storage, it's the communication and the obligations to take it away when that person is no longer an employee. So if you use employment information after a person's left work, for instance, like a reference, the employee exemption doesn't exist under privacy law anymore. In Victoria, New South Wales, and in a funny way in other states through delegated legislation, there are health records legislation as well. Okay. Now, the health records legislation is much more strongly policed than the privacy legislation. As I keep saying to people, if you breach privacy in Australia, the Australian Commissioner for Privacy is actually a cat that eats whiskers and never prosecutes. In New Zealand, it is a ferocious lion that comes out and beats everyone to death. So a breach of privacy in New Zealand is actively pursued, okay, very aggressively. Okay. Here, under health records legislation, particularly in Victoria, which has somewhat been industrialised by unions complaining to the Commissioner, there are significant fines and quite intrusive behaviour by the Commissioner. So again, we create and capture health records. Where do we do? Workers' compensation. Now remember, under all workers' compensation legislation in Australia, information you collect around health for workers' compensation can only be used for workers' comp. So if I find that Karen is not fit for the inherent requirements in workers' comp, I can't use any of that evidence to terminate her employment. I have to go and get fresh evidence. Yeah,
that information should be stored very separately.
Yeah. So I just want you to understand that basic part of it, but I want you to understand we're always collecting health-related information. Yeah. We are always collecting personal information. The fact that I know the names of Karen's children is personal information. Karen's address is personal information. Her date of birth is personal information. Whenever we get information, ask why are we collecting it and what we use it for. And why I want to have this discussion is with 3 clients recently, we've had very significant issues in health information, which has been provided by employees as a result of our management of that employee. One of them with actually in-house physiotherapists managing people, and that information being used at a later stage for selection and re-employment of people, or for managing inherent requirements issues. But the person never gave that consent. See, in privacy law, where health information is not being used for the purpose for which it was captured without adequate consent, you can't use it beyond that. So the key issue is an informed consent. Not just consent, it must be an informed consent under privacy law. So can I just remind you that if you do use it wrongly, you have discrimination law issues, massive discrimination law issues. You have significant breaches of safety law if you have information that tells you of a risk and you don't act on it. And you have workers' comp law saying you can't use it except for this purpose. So do you see what I'm trying to say? What's at the heart of this? A proper privacy policy and process that has proper consent, skilled supervisor and leadership who feed that information in so that we have red areas. We know when people are at risk. So we can fulfil in Victoria, for instance, Section 22, monitoring health. We're actually seized with the evidence, whereas at the moment, nearly all of you are not allowed to look at the evidence that you hold. A dangerous place to be, because when you do, you committed adverse action. When you do, you breach workers' comp legislation. When you do, discrimination law. When you do, it is not just under unfair dismissal if you terminate. Just is, did you do it lawfully? That's what just means. So every remedy that you have is taken away from you unless you get good consent. Now, if you want to know more about this, I'm happy to dig down further, but I just want you to understand, I know privacy seems like a silent area because the Federal Commissioner is a Gumby. Oh, sorry, he's inactive. His input is no longer living. No, I don't know what you say, but the truth is it plays out in every other area of law and it plays out in a much larger scale. Yeah. Am I a bit stressed today? I think so, yeah. Okay,
can we answer a quick question before we jump on? So Kate is asking, can the declaration of the pre-existing conditions be in the actual letter of offer?
Yes, it can, and there's a clause in ours, Kate. So I think you've actually probably got one of our standard forms and you'll see it's in there. Okay. Can I just say to that, Kate, there's one other issue, which is if we're doing pre-injury assessments, there's a case called Toll and Alice, which says that we need people to do more than just say what their pre-existing injuries are. Because remember, if someone doesn't tell the truth about a pre-existing injury when you're doing an assessment on them, it is a fundamental breach of their contract of employment. It's a lie, and therefore permits you to summarily terminate them. But it must be brought home to them that that is the case, and it is. And the reason, Kate, we use a statutory declaration is it applies their mind to the fact that it would be criminal if they didn't do it. If you don't have that under Toll and Alice, it's unlikely you'd be able to go to terminate when you found out later it's not true. Okay, so that's why we put it in standard form contracts for people who don't want to use the declaration, but our preference is that it is a statutory declaration and it sits aside.
Yep, cool.
Whew, case study. Let's go. Let's see how many other people can come into our room playing drums and timpani. All right, case study. Sarah had worked as a sous chef in a restaurant chain partly owned by the celebrity chef Gordy Goaty. Goaty was a flamboyant but at times abusive leader in his restaurants. You'll see there's no simile to any other person with the name Gordon in this. Sarah had worked directly beneath him and had suffered his wrath. She had a prior workers' compensation claim, which had been accepted relating to his bullying. She was diagnosed with an anxiety disorder and depression, a disorder which remained a problem for her, but was well controlled with medication and psychological support in the years that followed. Sarah resigned from whatever the name of the restaurant was in 2019 after working there for 5 years. Next slide. In 2022, Goaty became the host of MasterChef. He sold 90% of the shares in his restaurant chain to a Singaporean venture capitalist who appointed a new head chef in Melbourne, Basil Bouillabaisse. Basil was a friend of Sarah and they had worked together for a prior 2 years at a Michelin star restaurant in South Yarra, which is surprising because I didn't know South Yarra had any. Basil told HR, sorry, I'm on this side of the river if you haven't guessed that. Basil told HR they should poach Sarah and an interview was arranged. Following the interview, the OHS team shared their notes about Sarah's workers' compensation history, as well as notes from the in-house psychologist who had managed Sarah. HR went on to reject Sarah as a potential employee. All right, poll. There we go, the poll's up.
I feel like I need a fan just to cool you down.
Oh, I need a fan. I need a friend, not a fan. Let's see how we're going.
People are thinking. Give it another 5 seconds, Andrew.
Another 5 seconds. Yeah, I've started breathing now. It's good.
All right, everyone. 3, 2, 1. That's most people. All right, excellent. Thank you so much.
Thank you very much. And let's blow this up so I can see it.
All
Just
right.
move it to the right.
Yep.
You can't see any of what I'm talking about.
Yep, I'll move it here. There you go.
Okay, could her history of mental illness be legitimately used for testing her fitness for work? So the question is generic. If it's on the evidence that we have in this slide, the answer is no, you couldn't use what they've got. Okay, really clearly. Why? Workers' compensation legislation precludes the use of it for this purpose, and certainly she never gave consent to do it. Yep. But the answer is, if we created a process around her mental health and the observations around her mental health, external from her actual workers' comp stuff. And remember, if someone has a mental health issue, one part of it's workers' compensation, the other is safety. It is your obligation. So if I had a mental health issue and I put in my workers' comp claim, Karen would manage the mental health issue under workers' comp, and she'd manage the mental health as an employee separately. And that would probably be getting some observations from a suitable professional in here, a psychologist, for which I could rely upon what the psychologist said, not in respect. So, interesting question. Was there any evidence that the restaurant chain, I can't read, could rely on to suggest that she was not fit for the inherent requirements of the job and the above facts? And I think the answer is no. They haven't even looked at what are the inherent requirements of the job, and she was clearly fulfilling the inherent requirements of the job at a South Yarra place. So I think it's pretty hard. The next question is, did HR breach discrimination law? And this is the test. So what is the protected attribute? Okay, the protected attribute is an illness. Okay, a psychological injury or illness is a protected attribute. Now, remember, in discrimination law, it's not whether the person can't do the job because of the illness. It is making a decision based upon either the effect of the illness or your perception of the effect of the illness. So this is a clear breach of discrimination. And can I just say, in current discrimination law, which is now paralleling, can I say that, paralleling? It is now the same as common law damages. This is a couple $100,000 claim. Yeah. And that's just general damages. If she wasn't able to get other work as a result of this, she resigned, whatever she did, or she broke down as a result of her rejection because she found out whatever it was, then you've got economic loss.
I don't think people appreciate how costly and damaging discrimination breaches are.
Yeah, well, we've talked about before. This happened 4 years ago, where there was a aligning in sexual harassment, sexual discrimination, with the common law and damages, but now it spreads throughout the entirety of discrimination. So just be aware there are big damages that apply to it. Did HR breach privacy policy? I think that's a green button. Yes. Did they breach workers' compensation? Absolutely. Okay. And there are penalties. Just remember, it's a crime to breach workers' compensation. So it's not a civil penalty like under privacy law. It is a crime. It is an offence. It's prosecuted through a court. It's a very different thing. So today, what I really wanted to focus on, I guess, is this. First is stress that CEOs suffer.
It's okay, Andrew. I want to take you for a coffee after this. No, actually, maybe tea. Maybe
no, I want more coffee. And the second thing, but more importantly, is we misunderstand how important health information is. Yeah. And in doing it, we just forget the human part of it. What's wrong with me, and that's a fairly substantial list, so we wouldn't have half an hour for that. But it's really no one's business unless it affects the way I work. And if I manage that through support that's external, I manage it through medication, actually it's just no one's business. And all of this law comes together to say, no, take your employee as you find them. And then safety law says, but watch them. Yeah. Be generous, be kind, watch them. And if something does go wrong, work with them. And then discrimination law says, and make adjustments. What is all this about? All of employee legislation is around protecting the integrity of human behaviour around employees. And as leaders, that's actually what we should be doing every day. So thanks, Karen. On that, we'll see you next week. Thank you very much. Bye-bye.
Thanks, everyone. See you later.